I'm Shawn Eyestone from Eyestone Law Offices. Today I'm going to talk to you a little bit about intestacy. Intestacy means dying without having an estate plan in place. Fortunately for you, the state legislature has set up some rules that will lay out how things happen. Unfortunately, no client I have had that has set up an estate plan, be it a will or a trust, has followed those rules. They've always opted out of them because they really don't make sense at all. It's sort of a saw the baby in half approach. So with an estate plan, you can have whatever you want to have happen. So if you want all of your assets to go to a surviving spouse, they can go to a surviving spouse. If you want them split between your children and your spouse, that'll happen. Without an estate plan, the statute has a formula about how the assets will be split between your children. If you don't have any children and you don't have a spouse, then all of your assets would go to your parents if they're living, and then to your siblings if they're not, and then nieces and nephews, and so on and so forth. So it's very important to lay out what your wishes are, because following those formulas can have unintended results. You may have a child with a situation where they shouldn't receive any funds, and they could end up getting a check for $10,000, $100,000, whatever the case may be. So you want to make sure that you have your plan in place that fits your family rather than relying on what the legislature set up to saw the baby in half.